case briefs, and so much more. LSData's got what you're looking for.
The courtroom saga of Raymond Vincent Nidds versus Schindler Elevator Corp unfolds as a striking narrative against age discrimination within the American workforce. The case, scrutinized by the United States Court of Appeals for the Ninth Circuit in 1996, posed a critical examination of the burden of proof oscillating between an employee and employer in incidents of perceived discrimination. At the heart of the legal battle was Nidds, a former elevator service mechanic, claiming age discrimination and retaliation as per the California Fair Employment and Housing Act against his erstwhile employer, Schindler Elevator Corp. The inciting incident was Nidds' layoff and subsequent replacement by a younger employee, a strategy that Schindler appeared to disproportionately favor towards older workers. Schindler defended its actions, suggesting a downturn in the company's construction branch mandated the layoffs and placed emphasis on Nidds' alleged lack of finesse with contemporary equipment. The aftermath saw Nidds accepting rehire, but was subsequently transferred to what he perceived as a lesser department, leading him to lodge a second complaint. Schindler then transferred Nidds to a service route through a high-crime housing complex. Nidds faced another layoff and in response filed an employment discrimination and retaliation suit. The court's decision, however, was not favorable to Nidds. They held that his evidence of discrimination and retaliation was inadequate, leading to a summary judgment affirmed in favor of Schindler. In a nod to judicial precedents, the court pointed out the lateness of Nidds' witness depositions, interpreting it as a lack of due diligence.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.